All right, good afternoon and welcome to our debate. In the interest of time, if you need to know more about our panelists, I'm going to invite you to read their bios, which are listed in your programs. I'm simply going to say for now that we have famed trial lawyer Steve Susman, who is extremely concerned that the civil trial is dying. And we have a very highly regarded professor and author, Renée Lerner, who wants to take a pillow and hold it over the nose of the civil trial and smother it until it dies a painful death. So this should be a very interesting debate. Professor Lerner will start by giving a 15-minute opening statement. That will be followed by a 15-minute opening statement from Mr. Susman. We will then have a Q&A, which I will lead, although I'm going to try to get them to engage each other if they can do so nicely. And we will then have very brief closing statements. Ms. Lerner will begin by defending the resolution. And the resolution is, the resolution of civil disputes by jury trial is obsolete. Professor Lerner.
Well, thank you. That was quite an introduction. I think Steve and I are ready to put on the gloves and get going. Many thanks to the American Constitution Society for sponsoring this debate and to you all for being here. For me, this is a treat. There are few things on this earth I enjoy more than debating Steve. There are one or two others, but I won't mention them now. Well, fortunately, Judge Hazel, as you can tell, is used to presiding over disputes that are contentious. And on this topic, Steve and I, as you'll see, have some differences. One thing we agree on, though, is the importance of this topic. These days, it's not uncommon to see lengthy proposals for reform of civil procedure that make absolutely no mention of the jury. In a way, that's not surprising, because in both federal and state courts, of civil cases filed, jury trials resolve fewer than 1%. In some states, far fewer. You may be asking, in that case, why do civil juries matter? Haven't we, in effect, abolished the jury? Yes and no. In practice, civil verdicts are vanishingly rare. Cases are decided on the pleadings, on summary judgment, or overwhelmingly, they settle. But all of this is done in the jury's shadow. If a case at law presents a genuine dispute as to material fact, as many cases do, then no one can decide those facts except a jury. In other words, our requirement of the jury blocks any other means of resolving factual disputes. This is a problem. I could go on for a long time about the civil jury's flaws, but we have limited time, and so I'm going to be concise. The most important problem is that civil juries are unpredictable. They are unpredictable as to liability and especially as to damages. Juries have biases. It's hard to explain complicated scientific or financial concepts to a jury of ordinary laypersons. The persuasiveness of lawyers like Steve matters more to many juries than the merits of the case. And compounding this unpredictability of jury verdicts is the lack of thorough appeal. Now, by appeal, I mean not just on questions of procedure. On questions of procedure, we have appeals galore. But I'm talking about appeal on the merits. It's often hard to know why a jury decided what it did, and the standard for reviewing a jury verdict is highly deferential. So parties settle based on their guess about what a jury might do, which may or may not be accurate. They estimate the costs of litigation, and they consider their own tolerance for risk. Much of this has little to do with the case's merits. Now, these are among the reasons why every other legal system either never had a civil jury to begin with or has abolished it. England, Canada, Australia, and New Zealand, our fellow common law countries, all once had the civil jury, but decided that they could do better. This raises a question that is vital. the civil jury has many shortcomings. This audience is knowledgeable about the legal system. You are interested in reforms and public policy, or you wouldn't be here. And so, there is probably going through your mind the quintessential question about any problem of public policy. Compared to what? It's all very well to point out that the civil jury has flaws, but what's the alternative? The alternative that most of us in the American legal profession think of is a trial to a single judge. Now, if all judges were like Judge Hazel here, we're in good shape. The job of deciding a case on the merits will get done, and it will get done well. But all of us in the American legal profession know that not every judge is like Judge Hazel. Sadly, some judges are biased, lazy, incompetent, or, in some localities and in some places, and at some times, corrupt. And so, knowing what we know about some members of the bench, we're afraid of what we see as the only alternative. We cling to the civil jury with all its problems. But there is another way. A bench trial to a single judge is not the only alternative. And sometimes we in the common law system think that we're the only ones that thought that there might be problems with judges. Not so. This has occurred to people in other legal systems as well. And they, to protect against these dangers, use safeguards. And I'm going to name some of these safeguards now. One of the most important safeguards is using a panel of judges. Other legal systems don't just use a panel on appeal. They often use a panel in the first instance. These panels allow colleagues to correct a biased judge. Besides, when it comes to factual and legal decision-making, several heads are better than one. So that's an argument that one often hears from Steve and other proponents of juries. Many heads are better than one. Precisely, which is why in important cases in the first instance, it's best to use a panel of judges. Now you may be thinking, a panel of judges in the first instance, that's expensive. But hearings in front of judges can be much more efficient than trials in front of juries. With judges, there is no need to conduct voir dire and the rest of jury selection. There is no need to instruct the jury on law, no need to administer rules of evidence. The law of evidence is a law of jury control. And we fear that lay juries may not be able to handle properly certain kinds of evidence, and so we spend time and energy wrangling over whether certain evidence should be admitted. This is clear in England. England, as I mentioned before, has essentially abolished the civil jury, and they have done away with the hearsay rule in civil cases, where judges decide them, but not in criminal, where juries decide them. Judges could come into court having reviewed written submissions from the parties and be prepared to ask questions of witnesses that get directly to the point. No juries means a more active bench and more control over time-wasting partisan tactics. A huge gain in efficiency is that judges could focus on different points in separate hearings and address threshold questions first. If a defendant is not liable, there is no need to hear evidence about damages. Such discontinuous proceedings are not possible with lay juries. It's not fair to ask lay jurors to keep coming back to court at different times. The jury requires trial of all issues at once, with related confusion and waste of time. Such sequential proceedings would help judges to control discovery. Judges can order and be more active in guiding discovery on each point as it arises. Parties should no longer be able to inflict or threaten to inflict horrible costs on each other with little gain in knowledge of relevant facts. Now, there is an advantage of jury trial. And that advantage is that at least a jury has to make a prompt decision. Deliberations do not drag on for months. The jurors want to go home. As I think every chief judge in the room will acknowledge, some judges will need encouragement to keep cases moving and to make prompt decisions on the merits. These incentives should include time limits. They should also include review of performance by other judges for timeliness. I'm interested to see what Judge Hazel thinks of that.
I have some thoughts.
One of the most important changes in shifting to judicial adjudication is that decisions on the merits would be accompanied by written opinions. These opinions would explain facts found and application of law to facts. Lay juries, of course, do not give reasons, at least official reasons. They cannot. The requirement that judges explain their reasoning to the parties and to the public is certainly more satisfying to the litigants, and it also acts as a safeguard. A biased or corrupt judge would have a harder time justifying a bad decision. And also, the reasoning of the judge or judges in the first instance can be thoroughly reviewed on appeal. And here we come to the most important advantage of decisions by judges, and that is a thorough appeal. In legal systems that rely on judges to make decisions, a thorough appeal is an absolutely vital safeguard. Appeals in these systems are often de novo, with no presumption of correctness attaching to the decision below, and not only of law, but of fact. So let me repeat that: de novo, law and fact. These appeals need not be time-consuming. Appellate courts and other systems often rely on the record that was developed below, though they may add to it if necessary. Our limited appeals, in contrast, are a legacy of the jury system. We try to control inputs, such as what evidence the jury hears or the judge's instructions on law. But we have little control over outputs, that is, the correctness of the verdict. Systems that use judges to decide cases on the merits are serious about guarding against error. And here I mean, of course, substantive error. Now, these are a lot of suggestions at once. So please allow me to list them again briefly. Panels of judges, including in the first instance. More efficient courtroom proceedings. Sequential proceedings in logical order. Focused, effective discovery. Incentive to keep cases moving. Reasoned decision-making. And appeal de novo, law and fact. Now, these features are not just some law professor's fantasy, interesting as those are. They exist in real life. What I've just described is the system of adjudication in civil cases in Germany, in France, in continental Europe generally, and throughout much of the rest of the world. Now, we in the US are so cosmopolitan, I would even say globally thinking in so many ways, when it comes to everything but our legal system. And it's a good idea for us in the legal profession to take a look around. Now, you may be thinking, well, that's fine for those other legal systems, but it's impossible here. I've actually had a lawyer tell me that. Not possible here. We have the common law, she said, and the adversarial system, and that's just the way it is. Such changes could never happen here. Actually, it is possible. It's been done. It's been done by administrative agencies that structure their adjudication well. And I hold up as an actual example the Patent Trial and Review Board, or otherwise known as the PTAB. The PTAB was created by the America Invents Act, signed into law in 2011 by President Obama. The PTAB decides, among other things, questions of patent validity. The PTAB has many of the features I've discussed here. 3-judge panels, requirements for written decisions, strict time limits, and thorough appeal to the Federal Circuit.
Speaking of strict time limits, we have about 30 seconds.
Yes. We should not be surprised that, unlike civil jury trial, the PTAB has proved popular with litigants. Compared to civil jury trial, the PTAB is a procedural Valhalla. There is a better way. Thank you. Make it?
Yeah. You left them an extra 15 seconds.
This morning, the 5 panelists on the plenary program agreed that the most serious danger to our democracy today is the disappearance of truth-telling. What testimony or tweet is credible? One panelist said the democracy is in jeopardy if both the executive and legislative branches begin to accept alternative facts. Another even suggested, quote, the jury is still out on that. I'm here to suggest that indeed trial by jury is the best way known to man to determine who is telling the truth, and that juries are the best way to check both judges and an overreaching executive or legislative branch of government. In arguing for the repeal of jury trials in civil cases, the Seventh Amendment, Professor Lerner ignores the fact that were it not for that amendment, we probably wouldn't have had a Constitution at all. As Alexander Hamilton noted in the Federalist 83, omission of a guarantee of civil juries occasioned the greatest opposition to the Constitution. 7 of the 9 states that were required to ratify the Constitution made their ratification expressly conditional on the enactment of an amendment preserving trial by jury in civil cases. At the time the Constitution was ratified, every state had constitutions that protected the right to trial by jury in civil cases. And today, 240 years later, every state still has either a constitutional or statutory procedure that guarantees civil litigants the right to trial by jury. We should hang on to trial by juries not because they are efficient or always right or always fair, but because they are better than the only other viable dispute resolution system, which is trial by a single judge. So Renée begins her pitch by saying, well, there's another, it doesn't have to be a single judge. She agrees with me that more eyes and ears and minds are better than one, which is a whole theory of the collaborative, deliberative process of a jury. And she says, why don't we just have juries composed of judges, which is what's happening in a lot of other countries around the world. Well, in the first place, it cost a lot of money, a whole lot of money, in a system where the public doesn't have any money even for the courthouses. Jury trials were suspended for a long time in California because the state didn't have enough money to conduct jury trials. Can you imagine there's no will in this country and look at the vacancies. We have over 150 vacancies today on the federal bench. And look at the judicial emergencies. We're not going to get a bunch of judges made available to sit in the courtrooms and decide disputes between civil litigants. Besides, if that option really made sense, I mean, if you could save money, for example, of rules of evidence or whatever else, voir dire, no voir dire, if that option really made sense, you would expect sophisticated companies in negotiating their business-to-business contracts to insert a provision like that with all of her points in dispute resolution. Last year, the Civil Jury Project at NYU studied the material business-to-business contracts of every public company filed with the SEC for the first 6 months of 2016. We looked at their dispute resolution clauses. Only 43% of them got rid of a jury trial, either by compulsory arbitration or by jury waiver. The other 57% of major companies obviously thought that in resolving the disputes between them, public dispute resolution by jury was a way to go. And as I recall looking at a lot of those contracts, I never saw anything that closely resembled what Professor Lerner suggested, 3 judges and all these other procedures. So if people want to try that, fine. Maybe she can talk some general counsel into that alternative. Today, trial by jury is one of the few remaining institutions of our democracy that is truly of the people, by the people, and for the people. It also has bipartisan support among the people. With money and politics and the requirement of unanimity in the jury box, voting as a jury may be the only place where a citizen of this country's vote counts. It provides citizens an alternative channel to provide democratic input and shape the law. In this country, perhaps more than any other, citizens value their freedom, and we have always been suspicious of authority. We want to decide ourselves, and jury service is the most visible form of being able to take the law into your own hands and decide for yourself. Now, I can't wrap myself in the Seventh Amendment, but need to respond to Professor Lerner's criticisms of the jury practice as it currently exists. One of her criticisms is that, well, in England and other countries that gave us the jury in the first place, it's been abandoned. So they must be right about juries being expensive, unpredictable, biased. But the history of the disappearance of the English system of the jury is quite different from what happened in our country. And largely, it was a result of them not having any men during World War I. They had a better way of selecting judges. Judges in England are barristers selected in their 50s and 60s at the height of their professional career. Not like the 90% of the trial judges in this country are elected. Most of those are elected in partisan elections. The federal judges who are appointed are subject, it's a political appointment. They are subjected on both sides to litmus tests. That is asking them, will you be biased? Will you commit to be biased? So, and all the research shows that judges who are elected rule in favor of the parties that they perceive are most likely to help them get into office or retain their seats. 9 out of 10, and we know post-Citizens United, money has flooded into judicial elections, and particularly at the highest level of judicial elections. 9 out of the 10 people in this country believe that judges who are subject to election are biased in favor of those who they deem to be political contributions. So we have quite a different system than England. Now let's talk about her comments that jury trials are slow. They are actually faster than bench trials or arbitrations. Judges, out of deference to juries, typically try a case without interruption, while they take breaks in a bench trial to attend to other matters. Arbitrators, who are judges who are paid by the hour, rarely are in a hurry to do anything. When a verdict is returned, and they're federal judges who are tired of making a federal judge's salary and they go join JAMS or AAA. Do they make the system easier or simpler? No, they bring the federal rules of evidence, they bring motions of limine, they bring ESI discovery. Anyone who has gone to arbitration knows discovery is just as expensive, and arbitration and bench trials take longer because not only are there interruptions, in a jury trial when the verdict is returned, the fat lady sings. In a bench trial or an arbitration, after the evidence is in, you've got to wait to get a transcript, then both sides file 100-page briefs. Then the judge calls you back in for a final argument. And then maybe 6 months or a year later, you get a decision. That's not faster than a jury trial. But the professor argues jury trials are more expensive. The expense of discovery, motion practice, and the trial itself does not differ for jury trials. And there's no difference between a jury trial and a bench trial, which explains, by the way, why bench trials have declined quicker than jury trials in this country. They are biased. The use of a jury questionnaire, voir dire, peremptory strikes, and challenges for cause make it less likely to get a biased jury than a biased trial judge. They are unpredictable. The existence of vibrant jury consultant industry, the popularity of mock trial, the use of bellwether trials, all attest to the fact that good lawyers can predict usually how a jury is going to rule, and most trial judges can do so too. If the results were so unpredictable, there would be more than the tiny number of new trial motions that are granted. Sure, jury trials can be complex and complicated, but we can solve that by bringing to jury trials many of the innovations that Renée would like to use with a 3-judge panel. Instructions in plain English, given at the beginning of the case rather than the end of the case. Giving the jurors the same power that the judges have to ask questions. Giving the lawyers the power to address the jurors. Make interim remarks to the jury before final argument. Giving the jurors the power that a panel of 3 judges would have to discuss the evidence before they finally vote. Back-to-back experts. Bifurcation. Plain English instructions to the jury given at the beginning of the case, not at the end of the case. These should all be used in jury trials before we decide that we should get rid of jury trials before they are too complex. Professor Lerner ignores completely the advantage that a jury trial offers to the litigants in terms of satisfaction that they got a fair shake. I have never had a client tell me after losing a jury trial, that jury was crooked, that jury was biased. Now, they have told me, I don't think we made our point properly, which is a criticism of me. But they have never said that the jury is biased or unfair. Every time I lose a case tried to the bench or an arbitrator, I get that complaint. It was that he was unfair. She was biased against me. She never listened. So the parties are willing to accept a judgment of a cross-section of their peers much more than they are of the edict of a single judge. And then there's a benefit of allowing citizens to participate in a jury, to collaborate with others. Everyone who serves on a jury loves it. The empirical evidence shows that if you serve on a jury and deliberate, even on a civil jury, you are much more likely to vote than otherwise. So at a time when we don't have compulsory military service, you're not required to go to work on a Job Corps or Peace Corps. Jury service is the one remaining duty we can ask citizens to perform, and they should be willing to perform. We can shorten the length of trials. We can set time limits. I'm preaching for that in every jury trial. No jury trial, civil trial should last more than 5 days. I'm all for that. And then you don't excuse people who are highly educated or highly employed because they have a hardship. You do get a cross-section of the people on the jury. So in a time when we live in a time of angry, populist responses to institutional failures. Anger at the government is great. Yet the jury continues to be an institution that captures the popular imagination as a positive engagement with governance. The evidence is overwhelming that jury service makes for better citizens. Yes, juries sometimes decide cases differently than judges. Yes,
15 seconds, sir.
sometimes they are unpredictable. But the founding fathers who gave us the 14th Amendment, they gave us the 7th Amendment, understood that. They understood that juries were not the most efficient way to resolve a civil dispute, but they insisted on it anyway. We should be very careful that we keep them alive in this country. Thank you.
Thank you, Mr. Susman. So, Professor, as Mr. Susman takes his seat, I first certainly want to note and appreciate your faith in me personally as a judge. But for the rest of my colleagues, what about Mr. Susman's point that judges are more susceptible to influence than the average juror would be?
Well, there are certainly problems with judges in this country. Fortunately, federal judges in general, I think, are relatively impartial. The problems are bigger in the states, and it's as Steve says, the problems are bigger because of judicial elections. Because you have to stand for elections every 4 or 6 years or whatever it is, and you've got to get renominated by your party, and you've got to get the votes. So clearly, that is a problem. And I think we've been using the jury as a kind of a dodge to avoid cleaning up the real problems with judges. And I have heard many stories, and I think Steve personally knows that judges are susceptible to influence by campaign contributors, no question about that. And we've got to face that and not hide behind the jury anymore.
Judge?
Sure, go ahead.
I learned in preparing for this, I never really realized it before, but at the time the 7th Amendment was passed, every state appointed judges. Elected judges were in vogue at the state level in the first 2 decades of the 19th century. Since that time, lawyers of the likes of Justice O'Connor and judges have gone around and preached that we ought to get rid of the election of judges. That has not happened in any jurisdiction. Once you give people the right to vote, you are not going to take it back. The people do not want to give up the right to elect judges. So, even if you repeal the 7th Amendment, you haven't solved the problem. You haven't gotten rid of civil jury trials because the 7th Amendment is not incorporated against the states. A state would be free by statute or changing their own constitution to get rid of jury trials entirely. None have in the last 200 years.
Professor, I wanted to ask you about this idea you have for the panel of judges. And Mr. Susman raised a point that I agree with, sort of a side issue. At first, I don't know where you're going to get all these judges who would be able to sit on these panels. But beyond that, I mean, judges, by and large, tend to come from government or corporate law. A large number of cases that we see, particularly in federal court, but probably also in state court, are frankly cases brought against governments and corporations. So whether it's a panel of judges or individual judges, aren't they less likely to reflect society in the same way that a cross-section of jurors would reflect society? And is that a concern in terms of an individual plaintiff getting their fair day in court?
Well, this is one of the reasons for the panel of judges, that you're more likely to get different perspectives on a panel. And I do emphasize, too, the importance of the written opinion, that you've got to write that opinion, you've got to justify the facts that you find, you've got to justify your application of law to facts. And this is something that a jury does not do. They say libel or not libel, they give damages awards, and nobody has a good sense of why they do it very often. So that combined with the fact that there should be thorough appeal, so that the appellate panel can take another look at it and say, is this right? Did they leave something out? Did they forget or discount certain evidence, certain rules?
So, Mr. Susman, what about the point that Professor Lerner raises that, a jury just checks a box, liable, not liable, they fill in something says $8 billion or $1, and that's it. But as a judge, as a bench trial, you have to write a long opinion. Doesn't that give the litigants more assurance that the judge actually thought about the issues that he or she was supposed to think about, and not a jury who might have thought about who knows what back then.
Judge, in the olden days, where you had general verdicts, where you answer I find for the plaintiff, I find for the defendant, you were right. Today, every verdict in a civil case is a special verdict. There are pages and pages of questions asking about discrete facts. Did someone know about something on this date? Was it in writing? Was it sent to the other side? And it's a chart, and the jury goes through and they check. They have to be unanimous on every answer, and they go through and they check it all. So by using special interrogatories to the jury, you get a pretty good idea of why you won or lost the case. I mean, the judge has got to then add it up and figure out who it's for. But I think this is just a case of careful instructions and carefully tailoring your special verdicts. And then you know exactly why you lost and what the reasoning of the jury was. And that courts of appeal said that's the way to do it, so we can review the evidence. We can review the jury's verdict to see whether it was against the weight of the evidence.
All right, I want to step back and ask sort of a bigger picture question. So in every marketplace, right, not just in the law, as there's new innovation that proves successful and more efficient, sometimes old ways of doing things might just sort of slowly fade away. So, now, I guess in the legal marketplace, we see things like arbitration, we see mediation, we see courts like mine who now have a special setup for magistrate judges to help settle cases. These seem like more efficient ways of resolving disputes. So why don't we just have a funeral for the civil trial and bury it and move on with our lives? What's the inherent value of the civil trial that you're fighting to protect so hard?
Well, I'm all for technology, and I can even foresee a day when instead of people sitting in the jury box, there will be screens. The people will be at their homes. They will be on like a Skype, 12 Skype screens, and the people will hear the evidence remotely and vote from the privacy of their home. Indeed, we may go there soon in selecting juries. So you don't go to the courthouse until you have been selected as a jury. Voir dire is done over the internet. You answer a questionnaire and you go research a person on the internet to see whether you have a strike for cause or want to exercise a peremptory challenge. The question is, again, I think it comes down to having people who are brought from various aspects of life, each of which 12 people have 12 different viewpoints, 12 different biases, all of which tend to cancel each other out. The 12 sets of eyes and ears, they see things, they hear things that a single judge does not hear. So I'm all for using technology to make that process better. I have proposed that we provide each juror with an iPad. On the iPad are the instructions in advance, a glossary, a chronology, the exhibits that are coming into evidence, and real-time, wirelessly transmitted to their iPads testimony as it is spoken from the stand. These are things that are easy to do. What has happened in our country, unfortunately, is that since the Seventh Amendment was passed, judges have been fighting and trying to grab back power from jurors, neuter the effectiveness of jurors by making sure that they are the dumbest people in the world and that they lack the tools that the judge herself has to decide the case. And so that therefore, you instruct them in a foreign language that they don't understand. You don't let them ask questions. If they ask you have a problem during deliberations, you say, go read the instructions again. We have done it to the jury. We need to make our jurors more capable of deciding cases, and we ought to use every bit of technology we have to do that.
All right. Sure, please.
Yeah, I just want to address the question about the jury being representative of the community, because that's something you hear a lot from proponents of the civil jury. The difficulty is that lawyers like Steve use voir dire and jury selection to try to tailor the jury to one that is more likely to give a verdict in their favor. So just to give you an example of that, a good friend of mine tries cases to juries involving patent infringements, and she represents plaintiffs. And I said, well, what's your approach to jury selection? How do you conduct voir dire? And she says, very simple. I try to strike from the jury anyone I think is intelligent or educated, because I want a jury that is more likely to give a verdict for my client. And less educated juries are more likely to find in favor of plaintiffs in patent infringement cases. That's what she said. And she said, you know, I can usually do it. There are only so many educated people on the jury, and I can usually strike them. And so then you get the jury that you get, not representative of the community, unfortunately. I think we have to consider carefully why we want the civil jury. And it's very difficult for this number of people, 6, even 12, to represent the community, particularly when you have voir dire going on. If you don't allow the lawyers to conduct voir dire, I think you've got another problem, which is you can get very biased jurors on the panel. And clearly you don't want that. So there's a serious consideration about why we have civil juries.
But what about the issue of civic engagement, looking at it from the perspective of the juror? So every juror that I have starts out complaining about having to serve. No one actually wants to be there at voir dire. We sometimes kid about it. But when I talk to them at the end, I'm often surprised about it. They almost always tell me that they have a greater appreciation of the system and our system of justice, having sat through the process, having seen the government, having seen, particularly when there's a strong defense lawyer, having seen the individual get a strong defense, and that there's something to be said for just that process from the juror's perspective. What about the issue of denying jurors that opportunity for a civic engagement?
Yeah, this question of educating the jury is an interesting one, and it does seem that many jurors, after their service, do seem more engaged in the civic process. That is far more true, incidentally, of juries in criminal cases than it is in civil cases. Juries in civil cases are much less likely to have that kind of engagement following their service. So that's a distinction, and I do support lay participation in criminal cases, in part for that reason. So that's one consideration. But I think there are so many drawbacks to using lay people in civil cases that any modest boost that you might get from participating in a civil case just outweighs the problems. And I think one of the difficulties is if Steve has his dream come true and many more cases are tried to civil juries, we will all in this room and beyond get many more summons for jury service. And we have to think about that, right? How will we respond if we get summons after summons for jury service, even if, in Steve's ideal world, we only spend 5 days at a time on these cases? Well, the thing of it is, as society has gotten more affluent, and there's no question that over the past, say, 70 years, this society has gotten a great deal more affluent. As we've done that, the value of our time increases. So the value of our work time increases because we can earn more by spending time at work, and the value of our leisure time increases because we have many alternatives for our use of our leisure time.
All right. We have to go to closing argument.
Okay.
You have 45 seconds to say whatever you want. You can address that or something else. But you have 45 seconds.
45 seconds, I can do it. The parties in any case can waive a jury. I bet, I haven't done the research, but I bet the judge will back me up, there are very few civil cases where parties who are entitled to a jury mutually agree to waive it. If it was such a bad idea, why wouldn't we have more of that? The second thing is that I have never met a person who served on a jury that wouldn't gladly serve again. They love it. Now, people who get summoned and don't serve are not so happy about it because we have not figured out a good efficient way to select juries. But those who serve love the experience. So what's this? I've never seen anyone say, I never want to do that again. They all want to do it again.
All right, last word, 30 seconds.
Okay. As to waiver of jury verdict, there's always one party out there where the facts and the law may not be entirely on their side. Or they may appear to be very sympathetic to a jury, and that party is going to want a jury verdict. And I think what we should seriously think about in this country are not only problems with the civil justice system, but with the criminal justice system. And I think we should put lay participation where it counts, where it should count the most, which is in criminal cases. And to do that, I think we need to leave civil adjudication to trained, paid professionals like Judge Hazel.
Good end point. So I was told that at the end of this, I needed to pick a winner, and unfortunately, we're out of time. So thank you for your participation, and we are done.